Yes, Mr Conlon.
Thank you, my Lord. To answer, my Lord, the Master of Rolls's point just before the short adjournment, as at the 30th of September 2014, Virgin America provided service to 21 airports in the US and Mexico with a fleet of 53 narrow-bodied aircraft. And I believe that was something referred to in the IPO documentation that was before the court below.
Right, thank you.
Now, just before we broke for lunch, I was dealing with the mixed-use scenario, some use of the Virgin brand on activities, some activities without use of the Virgin brand. And I wanted to make this point, that the court ought to bear in mind that Alaska could have argued that no royalty at all was payable in that mixed-use scenario. Reading the clause very literally, Alaska could have said, well, as soon as any non-Virgin branded activities are performed, no royalty is payable, not even a royalty on Virgin branded activities, and not the minimum royalty either. Read literally, that's what the words "without the payment of royalties" appear to say. Now that obviously would have been an absurd argument, and Alaska's not made it. But it is critical in my submission to tease out what exactly is revealed by the fact that Alaska doesn't make that argument, and that instead it accepts that in the mixed-use scenario, quarterly royalties are payable on Virgin branded activities, and at the end of the year, top up to the level of the minimum royalty will be due. By not making the argument that no royalty at all is due in the mixed-use scenario, what Alaska is acknowledging is that what the clause really means is that there will be no royalty payable on the non-Virgin branded activity, not that there will be no royalty payable at all. And it's only the non-Virgin branded activity that is carved out by clause 3.7. But if that is what the clause means in the mixed-use scenario, it must be what it means in all scenarios, including the scenario where all use of the Virgin brand ceases. So the important point we make is that Alaska doesn't disagree with our construction or interpretation of 3.7 in the mixed-use scenario at all. So this is not, in fact, a classic case of rival constructions. It's a rather more unusual case where the parties agree about the correct interpretation up to the moment where Alaska ceases using the Virgin brand altogether, which is what happened at the end of May 2019. At that moment, Alaska says 3.7 developed a new target, and according to Alaska, for the first time, it did extend so as to capture the minimum royalty and would have the effect that no minimum royalty would be payable at the year-end reconciliation. There is, however, in my submission, nothing in the clause to suggest that it develops that new aim and focus at the moment that all use of the Virgin brand ceases. And we submit the clause has one meaning, one application, rather than one which applies some of the time, and another one which applies on and after one particular moment in time. Now, in order to conclude that the clause develops a new target at the point of cessation of all use of the Virgin brand, it would, we say, be essential to find some wording that makes that clear. We say there's nothing of the sort. The clause doesn't say that it will apply differently depending on whether some use is made of the Virgin brand or no use at all. In fact, as I said right at the outset, the clause doesn't refer to cessation of all use. What it refers to is the user not using the names or marks while undertaking such activities. And as I've said, those words indicate that the permission and the exemption set out in the clause concern one set of activities, that is the non-branded ones. Those are the activities that Alaska may perform and is exempt from the payment of royalties in respect of. So the bottom line in my submission is that clause 3.7 doesn't purport to define a set of circumstances in which no royalty at all will be payable, and it doesn't contain words apt to do so. You cannot read this clause as identifying a total cessation of use of the Virgin brand as the trigger for the non-payment of all royalties, while still giving meaning to each part of it. And to test that, can I ask the court to think about the permission to perform non-branded activities, which is what 3.7 begins with. That permission is obviously not limited to a situation in which all use of the Virgin brand ceases. Neither party suggests that it is. The permission extends to any situation in which Alaska performs activities without using the brand whilst undertaking them. This is where you see the significance of the final words in line 6 of the clause. If that is correct for the permission, and we submit it obviously is, then it must also be correct for the exemption from royalties, because the permission and the exemption from royalties go together. They are obviously identical in scope, and they apply in respect of the same non-branded activities. And I would add this, that it's also, in my submission, inherently implausible that the clause would not prevent recovery of the minimum royalty where some use is made of the brand, however small, but would suddenly extend to the minimum royalty when use falls to 0. We described that in our skeleton as an unattractive and anomalous interpretation.
Well, I think you've already made that
I
point
have,
about 3 times, Mr. Toledano.
My lady, yes, that's fair. And I would add this point as well, that in a sense, the argument doesn't really work anyway, because even in the case where there is no use on activities, in a sense you are still using the rights because you're excluding others from using them. And by excluding others from using them, in a sense, you are still doing something with the rights. Now, on our construction, by contrast, the anomalies don't arise. The clause means the same thing, has the same application, even where use of the Virgin brand ceases. In that scenario, Alaska need not pay quarterly royalties on the non-branded activity, but it must still pay the minimum royalty simply because the minimum royalty is not a royalty on non-branded activity. It is the minimum amount payable annually throughout the term for the grant of the rights, however much use is made of them, revenue generated, or no use or no revenue at all. I'll come back to the commercial considerations a little later, but there is nothing at all we submit surprising about the clause that provides for a minimum payment in return for the right to use something. If the licensee chooses not to use or hardly to use, that's a matter for it. It still has something of value. It can keep
That's
others
the whole
out.
purpose of a minimum payment.
Exactly.
To protect you against the fact that they're not going to use it for as much as you would hope that they would in order to generate more.
Exactly so. I entirely agree with that. And of course, one shouldn't lose sight of the fact that Alaska can change its mind at any time, and it can decide to use the brand again if it should so choose. If it decided that a particular route, for example, would benefit from the Virgin branding, at any time it can choose to do that. As I said earlier, we do submit that 3.7 and the minimum royalty pass like ships in the night. Alaska's case, which is that they pass like ships in the night in all scenarios except where all use of the Virgin brand ceases, simply doesn't work. And there are 2 further fundamental problems with Alaska's interpretation that I want to mention now. First, if you read the clause the way Alaska does, you have a problem if use ceases 1 month but starts up the next month. For example, because Alaska changes its mind about a complete D brand and instead decides to retain the Virgin livery on 1 or more of its routes. Now, on Alaska's case, 3.7 would have ruled out the minimum royalty during the month of no use, but would then permit it again once some use started up. Yet there's no machinery in the contract to cater for such scenarios by, for example, apportioning the minimum royalty between periods of no use and periods of some use. That's the first.
Isn't the minimum royalty relates to a particular year?
It does, and indeed.
Why is it not the case that if I thought it was accepted if there was any use at all of the brand, then the minimum royalty would be payable?
Well, their argument is that you apportion the minimum royalty. Indeed, that's what they. That's I think ground 2.
Completely removes the whole concept of a minimum royalty.
That's our argument, that when you come, that there is no concept of apportionment here. If there's any use, then obviously you have to pay the minimum royalty for that year, and it's an annual exercise. The second point I wanted to address was what we've called scenario 3, which is where all commercial activities cease. So let's take the example where Alaska acquired Virgin America in the same way that it did in December 2016, but instead of thereafter merging their operations, Virgin America's assets had been transferred to Alaska and Virgin America had ceased operating. Now, we know that 3.7 allows Alaska to elect to perform non-branded activity without the payment of royalty. That's what it says. Where Virgin America no longer operates at all, no operations, neither with the brand nor without the brand, the clause 3.7 obviously has no application because it's all about electing to perform non-branded activities. Now, if it has no application, then obviously the minimum royalty will remain payable annually. Now, that makes total sense on our case because it's payable annually throughout the term, regardless of the extent of commercial activity, regardless of the use of the Virgin brand. But it makes no sense on my learned friend's case because on his case, the minimum royalty is not due where the airline continues in operation but doesn't use the brand, but the minimum royalty must be due where the airline ceases to operate, because 3.7 can have no application in his favour. And that is, with respect, obviously illogical. And Alaska had no answer to this point, which we made in the court below, and it hasn't answered the point now either. And importantly, we submit that the no commercial activity scenario doesn't only introduce a further illogicality into Alaska's argument, it demonstrates that their interpretation, which they summarised in the court below, and I think they still summarise now as no use, no pay, in other words, no use of the Virgin brand, no payment of any royalty, that summary of their case is obviously incorrect. If that's what the clause provided for, then the minimum royalty would not be payable in the scenario where there was no commercial activity at all. Yet even on my learned friend's case, it must be payable in that scenario. And again, Alaska cannot answer that point.
Well, wouldn't their answer be that in that scenario they'd be caught by 3.6?
Sorry, my lord, what would be caught by 3.6?
Well, in the scenario where they cease any operation at all, they can't rely on 3.7 because they haven't elected to perform.
Exactly so.
But they'd be in breach of 3.6.
Well, they'd be, on our case, they'd be in breach of 3.6 if they carry on the licensed activities but don't use the brand, at least to some extent. They're not in breach of 3.6 if they cease all commercial operations, because this 3.6 is directed at the situation where they do carry on the licensed activities but they don't use the brand at all.
Because it says for as long as it provides the licensed
Exactly.
activity.
Exactly so. So this is why I say that in the no commercial operations scenario, none at all, on my learned friend's case, he'd have to accept that the minimum royalty is payable. And yet that can't make any sense on his case because he's saying, well, if they carry on the operations but they don't use the brand, they don't have to pay, but if they have no operations at all, they do have to pay. That obviously doesn't work. And there's one final matter I want to address before I turn to the history and the factual matrix. I said I would come back to 3.6, which my Lord Justice Phillips just raised with me. Now, as you know, that clause arises primarily as regards ground 3, which concerned the judge's alternative conclusion that by ceasing all use of the Virgin brand, Alaska was in breach of 3.6, such that we could recover damages equal to the value of the minimum royalties. And I'll come back to ground 3 later very briefly. But for now, I simply want to make the point that if we're right about the meaning of 3.6, if, as we say, that clause does impose a minimum use obligation, then that does reinforce our interpretation of 3.7, because it makes no sense to suggest that the parties agreed in 3.7 that cessation of use of the Virgin brand would bring to an end our right to recover the minimum royalties, whilst at the same time agreeing that cessation of all use of the Virgin brand would be a breach of 3.6. Cessation of all use cannot have been a relevant tipping point under 3.7 if it was actually a breach of contract under 3.6, from which it must follow, we submit, that if we're right about 3.6, we must also be right about 3.7. Now, I don't want to place too much weight on this point because we don't need it. We've got all of the other arguments about 3.7 that I've made, which stand independently of 3.6, but we do submit that 3.6 is a yet further factor in our favour. I'm now going to turn, if I may, to the history of the TMLA and the involvement of the Department of Transportation. As you've heard, there's no doubt that 3.7 was introduced into the 2007 TMLA as a result of the interventions of the DOT. As I think you will have picked up, the DOT's first show cause order, dated the 23rd of December 2006, tentatively concluded that Virgin America was not a US citizen. And the DOT accepted in that document that some degree of influence by Virgin over Virgin America was legitimate, but they considered that the then proposed arrangements gave Virgin too much control. So they said, tentatively, not a US citizen. Now, Virgin America responded by suggesting that they would make changes to allay the DOT's concerns, including changes to the TMLA. And one of the proposed changes was to make it clear that Virgin America could conduct activities without using the name Virgin, without using the Virgin marks. And at least initially, the proposed drafting provided by Virgin America said that they would nonetheless have to pay royalties to Virgin on all activities. And that was the footnote that my learned friend showed you in the supplemental bundle at tab 3, page 64 this morning. And that led to the March 2007 show cause order from the DOT. That, as you've heard, reversed the initial order, tentatively found that Virgin America did meet the US citizenship test, subject to some further conditions. One of the conditions, but not the only one, concerned the TMLA. And I just want to invite your attention briefly to what they said in that March show cause order. It's in the supplemental bundle at tab 5, at page 124 of the bundle in the hard copy. I think you might have to add 3 if you're looking at the screen. It's internal page 57 at the top of the page. I hope you have that. And then if you look at the first paragraph on the page and the last 4 lines of that first paragraph, that's where the DOT made it clear that they wanted the permission to perform to extend to any operations so long as the Virgin name was not used in those operations. So that's the permission part of all of this. Then if you look at the last 6 lines of the third paragraph, just above the heading for voting trust, you can see what the DOT said about the royalty obligation. And they said, however, which is about halfway through that final paragraph above item 4, however, we see no reason why the applicant's operations outside of the license should still be subject to a royalty obligation to the Virgin Group. Now, pausing there before we look at the next sentence, note please how the DOT saw the Virgin branded and non-Virgin branded activities as separate operations. The operations within the license and those outside of it. Now, if, as we say, the minimum royalty is a payment for the right to conduct the Virgin operations within the license, whether in fact you do or you don't, then it necessarily has nothing to do with the separate non-branded operations that sit outside of the license. Then if you look at the next sentence on from the one we were looking at, which is the key sentence, the DOT said, payment of royalties on revenues not derived from use of the brand name would undermine the applicant's independence. And they proposed a condition that would allow such activities to occur without royalty obligation. So the DOT's express concern in 2007 was in respect of revenues not derived from use of the brand. In other words, they wanted to ensure that non-Virgin branded revenues would be carved out and not included in the royalty calculation. That, in my submission, precisely accords with our construction of 3.7 in this case. And that's why our case in the court below was that the DOT history supported our case, even though it was actually Alaska which had introduced the history of discussions with the DOT, not us, that originally relied on it. It was Alaska that relied on it, but our case has always been that if you are going to look at it, it actually supports our analysis of 3.7. And as you know, at the end of March 2007, changes were made to the TMLA as a result of this March order, and those changes resulted in the form of clause with which the court is concerned on this appeal. And in the DOT final order, which you have at tab 10 of the supplemental bundle, starting at page 191, if you look at 194 in the hard copy, you will see in the second paragraph on that page, 194, that the DOT referred to its earlier March order that I've just taken you to. And if you look at the last 5 lines of the second paragraph, they repeat the sentence that I drew attention to from the March order: payment of royalties on revenues not derived from use of the brand name would undermine the applicant's independence, and they introduced a condition to that effect. So my submission is that, and as it was below, is that the primary role of 3.7 was to permit all kinds of commercial activity without use of the brand, and the royalty exemption was added in order to prevent there being, in the DOT's words, any payment of royalties on revenues not derived from use of the brand. That was the purpose of 3.7, and 3.7, as we know, didn't change between 2007 and the current version from the 2014 agreement, and therefore it should have the same meaning in both contracts. Now, as we point out in our skeleton, it is of course correct, and we accept that under the 2007 arrangement as a whole, if Virgin branded revenues fell to zero, there would be no royalty payment due. And that's simply because there was no minimum royalty provision in the 2007 contract, only the quarterly royalty payments. So if branded revenue fell to zero, there'd be no gross sales to take into account under Clause 8. Any gross sales deriving from non-Virgin branded activities would be carved out as a result of 3.7. Similarly, if Virgin branded revenue halved, the royalty payment would also halve. Those consequences mustn't, in my submission, be confused with the meaning of 3.7. The clause did not mean no use, no pay, any more than it meant half the use, half the pay. Those are consequences that flow from the operation of all of the clauses of that particular 2007 contract taken together. Now, moving on in the chronology, in the period between 2007 and 2014, as I said just before the break, Virgin America operated successfully as a domestic airline in the US. Unsurprisingly, the Virgin name and marks were an integral part of its operation. They formed part of its name, they appeared on all of its aircraft, and so on. Now, just before I turn to the position in 2014, when the current TMLA was concluded, I should just mention that at the supplemental bundle, tab 12, there's actually a letter from the DOT dated the 8th of January 2010, and that letter, I don't think the detail needs to concern you, but it describes a number of changes that Virgin America had undergone even by early 2010, which had further loosened the Virgin Group's influence over Virgin America. And those changes were approved by the DOT, which confirmed that Virgin America remained a US citizen. And I don't think, as I say, that the detail matters. Then we come to 2014, and I want to emphasise, if I may, a number of features of the factual matrix that the judge reached conclusions about. And you'll have seen, I think, from his judgment, that during the course of the trial, the learned judge heard both factual evidence about the events of 2014 and also expert evidence about the approach of the DOT. And in my submission, that no basis has been suggested by Alaska for this court to disregard or modify any of the judge's conclusions about this evidence. And the first feature of the factual matrix evidence I want to mention is the one I mentioned just before lunch, which is that in order to facilitate the proposed IPO by Virgin America, the Virgin Group gave up a series of important control rights in respect of Virgin America, as the judge accepted. And we've summarised them in our skeleton at paragraph 35 on page 62 of the bundle. Essentially, we gave up, or we diluted some of our shareholding in Virgin America, number one. We lost a series of veto rights, number two. We'd only be able to appoint one director to the board rather than, I think it was two beforehand. The most important of those is the fact that we gave up the right to block sales or mergers of Virgin America or its assets to a US airline, or to block sales of Virgin America shares to persons operating or owning such an airline. Now, that giving up of control rights by Virgin was significant for two reasons. First of all, it meant that the DOT would have even less reason to be concerned in 2014 than it did back in 2007, because Virgin's influence over Virgin America had been further weakened. And the judge accepted that point in his judgment at paragraph 158, subparagraph 1. The second reason that Virgin's giving up of control rights was significant is because it increased the risk that Virgin America would thereafter be acquired by a competitor and debranded, which is, as we know, what happened in 2016 when Alaska acquired Virgin America. And the judge accepted that point in his judgment at 158 subparagraph 2. Now, another important feature of the factual matrix was that Virgin America wished to extend the term of the TMLA. As I said before lunch, it was due to expire in 2022. No one thought the revenue thresholds for extension were likely to be met. Virgin America's bankers, in the context of the proposed IPO, wanted a longer-term right to use the Virgin brand, which was seen by them and by Virgin America as essential to a successful IPO. And the judge concluded in his judgment that the extended term was a valuable right from the perspective of Virgin America. And he mentioned that several times in his judgment. I'll give you the paragraphs. It's 158 subparagraph 3, 161 subparagraph 3, 162 subparagraph 2, and 162 subparagraph 3. Now, my learned friend says the IPO was a common goal of the parties and financially beneficial to both parties. He says the IPO would benefit the Virgin corporate group. The judge didn't make any findings about the benefit of the IPO to the Virgin corporate group, so I'm not really sure what my learned friend is basing that part of his argument on. As I've said, what you will find in the judgment are several references to the value of that extended right from the perspective of Virgin America and from the perspective of what its bankers were demanding in the context of the IPO. Now, in return for agreeing to a longer term of 25 years from the date of the IPO, Virgin sought and obtained, as you know, the inclusion of a minimum royalty. And I just want to invite your attention to how that was described at the time by Virgin. It's supplemental bundle tab 13 at page 225 in the hard copy. So it might be 228 possibly in the PDF. So this is an email in March 2014. It's the bottom email on the page at 225, and you can see under the heading Gross Revenue Test Minimum Royalties. As discussed, the idea is not to trip you up, but to give us, that's Virgin, comfort over the scale of the business, our return against the backdrop of a longer term license with no break clause. So the minimum royalty was designed to give Virgin comfort over the scale of its business and its return against the backdrop of the extended term of the license. And I just want to show you, if I may, what the learned judge concluded about these things in his judgment. It's 161 subparagraph 3, so that's in the core bundle at tab 7, page 138. And you can see he says in subparagraph 3 of 161, he refers to what he regarded as the most important aspect of the factual matrix, namely the degree of uncertainty introduced by the other changes to the 2007 TMLA in 2014 and the risks undertaken by Virgin as a result of the changes. He goes on to say it's clear that viewed from the perspective of Virgin America, the extension to the right to use the brand was a valuable one. It's also clear, he says, that Virgin was losing a substantial number of rights of control and that there was, as a result, an enhanced risk of a debrand. In these circumstances, I think that it's a reasonable commercial conclusion to reach that Virgin would wish to assure themselves of a guaranteed minimum income going forward. And while we're looking at the judgment, so that's what he concluded on the factual matrix, having heard all of the evidence. If you also look at 162, which is over the page, we can quickly look at 162 sub 2 and sub 3. Those are two of the passages where the judge made findings about what Virgin America wanted and what was in its interests. And then if you look at 162.4, you can see the judge made reference to comfort in return for agreeing to the longer term license. And that's clearly a reflection of the email that I just showed the court. And then 162.5, now that paragraph needs just a little bit more explanation. That the judge heard expert evidence at trial about the difficulties that Virgin faced in seeking to reuse the Virgin brand in the context of a US domestic airline. That expert evidence about the challenges Virgin would face if it sought to reuse the brand was additional to the expert evidence about the DOT processes that I've already mentioned. And unsurprisingly, Virgin couldn't just terminate the contract and immediately reuse. have to find another way of doing so by, for example, setting up another airline or licensing to an existing airline. That required considerable investment, especially from US investors, and carried considerable risk. Indeed, the evidence at trial showed that by 2014, Virgin had invested over $600 million into Virgin America since its launch, and that's referred to in a slide at supplemental page 231, but I don't think there's any need to turn it up now. By contrast, Virgin America obviously already had a successful business under the Virgin name, and that is essentially what the judge is accepting in this paragraph. And I would add that the judge expressly concluded that our expert evidence about the difficulties of reusing the brand was relevant and admissible and formed part of the factual matrix of the contract in 2014, and that's in his judgment at paragraph 68. And I would also add this, that this point is the answer to my learned friend's reliance on the second half of clause 3.7, which gave Virgin the right, but not an obligation, to terminate the TMLA if Virgin America's use of the brand ceased in a material manner. True it is that we could terminate in that scenario, but that's of no comfort or little comfort if seeking to reuse the brand is difficult and risky and requires very significant additional investment. Termination cannot do away with the need for a guaranteed stream of revenue. Now, so far as the DOT's involvement in the 2014 process was concerned, as I think you've seen from the judgment, the judge concluded that the DOT saw a red line of the changes to the TMLA, including the insertion of the minimum royalty provision, and as you saw this morning in its letter approving the arrangements dated the 20th of October 2014, which is in the supplemental at tab 24, the DOT expressly referred to the minimum royalty provision. So there's no doubt that it understood that that provision was being included in the TMLA for the first time. The DOT also referred to the fact that the TMLA would continue to permit Virgin America to operate independently of the Virgin brand without the obligation to pay royalties, which was obviously a shorthand reference to the fact that 3.7 remained in the contract and had not been amended. Now,
if I read have a difficulty, I think as my lord mentioned earlier, when DOT has sent a red line of this agreement, what does what it thought matter in any way?
Well, I would say what it thought doesn't matter, and also that we don't know what it thought. We only know that it knew about the provision, and it didn't raise any objections.
And what does that matter in any way?
It doesn't, only insofar as Alaska has always made a case based on what the court can conclude from the DOT's analysis of these matters.
I have a great difficulty with all of this factual matrix. And you can see from the agreement that a 25-year term was being agreed, and you can see from an agreement that there was a minimum royalty which was agreed, which plainly was comfort to your client. I'm not sure how any of this analysis takes that anywhere further forward. I mean, the only very simple question is whether Alaska is right that in the one unique scenario, the 0 is a special number. If it goes to 0, they don't pay any royalty, and they say that's the effect of the wording of the clause, and that's the only thing we're looking at here, isn't it? I just don't see the relevance of any of this background material.
And I'm not trying to dissuade.
So why are we going through it?
Well, because an argument has been made all the way along that the court can somehow be assisted to reach the conclusion sought by Alaska if it delves into
but you're
factual
not saying
matrix.
that's the case, as I understand it.
I'm saying that you don't need the factual matrix to assist you because the contract is clear, but that if you're going to look at the factual matrix, if anything, it supports my analysis because it makes it clear that what the DOT was concerned about, even back in 2007, was revenue on royalties not derived from use of the brand. And that's the paragraph that I showed you in their show cause order. But my lord, the point you're putting to me, in a sense, I accept, because you're right that you can find things like the fact that the term was being extended. You can find that obviously within the four walls of the contract. But I suppose it does add something to say that this was something that was sought by Virgin America, that their bankers wanted it in the context of the IPO.
Everything that goes into a contract is sought by one of the
Somebody.
parties.
Yes.
I mean, we're talking about basics here, aren't we? We've got an agreement which has been negotiated with the involvement of sophisticated solicitors, with a clause saying, an entire agreement clause.
I'm not trying to persuade you otherwise. Just to draw your attention to 160, subparagraph 1 of the judgment, where the judge made it clear that, insofar as it's relevant, that the DOT was fully appraised of the terms of the contract. And then there's just one other paragraph to remind you of, which is 162, subparagraph 6, where the judge also concluded that there was no question of Virgin America having acted in breach of any US statutory obligations. In other words, the fact that they hadn't done more to spell out the consequences of the new aspects of the current agreement didn't in any way put them in breach of any US statutory obligations. But there
all
it
of
is.
that is by the by, as my lord says. The DOT may have had concerns that Virgin America should have a degree of autonomy. You've got a clause that satisfies the DOT that has come about, that they have a degree of autonomy, and that they don't have to pay royalties on that side of their business if that's what they do. Doesn't help to answer the question of what clause 3.7 means.
I agree.
At all.
I would respectfully agree with that, and I would also add that you can't get anywhere trying to speculate about the position of the DOT, not least because we know right from the beginning they said a degree of influence on the part of Virgin is perfectly acceptable. So trying to work out where they would or wouldn't in their own mind draw the line is obviously not going to be very fruitful.
But also, what they were satisfied by was what was presented to them. What that means is a
Something
different
else.
matter.
Was there any argument, Mr. Toledano, about the admissibility of all these witnesses giving evidence about it and all the material that both parties seem to have put in front of the judge and the 5-day hearing or 4-day hearing? I mean, the whole thing strikes me as totally overblown.
Well, it's a fair question. I don't think. I think both sides accepted that evidence about what happened in 2007 vis-a-vis the DOT would be a relevant and admissible part of the factual matrix, and that therefore the court could take into account that evidence, and that's why there was evidence from experts about that. So I think the short answer to your Lordship's question is I don't think anybody suggested that it went too far to start looking at the 2007
Presumably,
history.
the commercial court judge at the CMC was persuaded there was a proper case for expert evidence.
Yes.
Or was it just consented to and waved through?
I don't recall, my lord. Certainly, permission was given. Whether it was whether there was serious argument about it or not, I don't
It's a
recall.
question of construction. I'd have thought the commercial court judge would be very wary about giving permission for expert evidence when the question's interpretation of the agreement.
Well, I mean, this is the meat and drink of the commercial court, and I'm absolutely astonished that a 5-day trial was allowed on a point that, frankly, we're struggling to fill a day here on.
Well, we would
and
be.
only because we're listening to stuff that seems to many of us to be slightly irrelevant to the very interesting and important issue, which raises quite a lot of money, I understand, we have to decide. But I mean, I'm worried why there was a 4 or 5 day trial with all this evidence, but apparently nobody contested it. So there we are.
My lord, yes, but as you've heard from my submissions already, our case is and always has been absolutely rooted in the contract, in the wording of the contract and in how the contract
When
works.
you both get up and say there's no ambiguity, the contract means what it says, and that's the beginning and the end of the case. I've seen that in Mr. Weisselberg's skeleton argument on paragraph 1. And if that's the case and you say the reverse, then there's not much scope for further argument. We've just got to decide, right?
Yes, I accept that one.
I mean, the idea that what the DOT wrote in multiple letters actually affects the meaning of the words the parties used strikes me as at least optimistic, even if it supports you or not. I mean, the whole purpose of the rules of interpretation are that you don't go down that road. Anyway, there we are. Well, you've gone down that road, and now you're here.
Indeed. I mean, I can, although I understand entirely where your lordship's coming from, I can, in the context of trial with the full pleadings, where the pleadings go back to 2007 and look at the genesis of the clause as it was introduced in 2007 as a result of the discussions with the DOT, you can see how you get to a point where it looks like you need expert evidence about the DOT and the processes of the DOT, and that's how it struck everyone below. But I'm not trying to dissuade your lordship that what really matters in this case is the clause in the context of the agreement as a whole, how that works, and whether our argument works or whether Alaska's argument works.
Excuse me, even if the DOT had considered the meaning of minimum royalty in this context, which it didn't, and even if it had expressed a view on what that meant, I don't think that would make any difference. It might possibly give rise to some sort of a stopper argument if there was, but and we're just so far away from anything that's relevant to an interpretation.
Well, I don't want to. I really don't want to look as if I'm sort of laying the blame elsewhere, because we didn't object to this expert evidence. But it is right to say that the case, the factual matrix case about the DOT and how that can assist in the interpretation of the contract, is not my case. It's Alaska's case. They introduced this. They pleaded it, and this was a case that they sought to bring. We have always said from the beginning that the answer to this case is in the contract. But we responded to that case about the DOT, and we brought our own expert, and we've made the arguments that we have about it. But it's not my case. So without wishing to, in any way, as it were, point the finger of blame, and I don't want to do that, but it is important that the court understands it's not my case, the DOT point.
Well, Mr. Weisselberg opened this morning by saying it was a case of a straightforward construction or interpretation.
Yes, my lord. And I think that's where both parties...
Mr. Justice Mello was on the defence in the original version.
A long time ago.
Well, a long time ago.
So I think I'm going to leave there, if I may, the factual matrix, because I don't think anything I say more about the factual matrix is going to assist. I just want to say something now, if I may, about the commercial consequences of the rival interpretations and commercial common sense. I think, in a sense, I've already identified the points through other remarks that I've made, but let me draw them together, if I may. First of all, we say it made perfect commercial sense for Virgin to seek a minimum annual fee, given three important considerations. One, the risk of a competitor acquiring Virgin America and then debranding. Two, the limited ability of Virgin to reuse the brand and the risks inherent in attempting to do so. And three, the extended term of the license that Virgin America wanted. And as I've shown the court, the judge concluded on all of those points in favour of Virgin's arguments. Secondly, from the perspective of Virgin America, it made commercial sense to agree to the minimum royalty because it was the quid pro quo for the very extension that Virgin America wished to obtain, and also because Virgin America saw the Virgin brand as highly valuable to it, not least because it had been successfully operating under its banner for some years and intended to continue doing so, subject to any future external developments. And it's only from the perspective of Alaska, post its decision to debrand, that the payment of an ongoing minimum royalty has become commercially unattractive. But that, we submit, cannot be the correct vantage point. The judge rightly concluded in 1611 of the judgment that the issues must be approached from the perspective of the two parties at the time of the contract, not from the perspective of Alaska or indeed any other third party who might have an interest in the future of coming along and acquiring Virgin America and debranding. The parties anticipated that a competitor might come along in the future in D brand, but they were not negotiating in 2014 so as to protect the commercial interests of that hypothetical competitor. They were negotiating so as to further their own commercial interests at the time. And as I've said, each of Virgin and Virgin America had their own commercial reasons for wanting to conclude the current TMLA. Thirdly, even if the court does take into account the commercial position of Alaska or some other third party that could have come along in their place, it cannot, in my submission, be suggested there's anything commercially unreasonable or absurd about Alaska being required to continue paying the minimum royalty.
Do we know what kind of royalties Virgin America was paying when it was flying 51 aircraft to 21 centres, or however many you said? I mean, presumably it was massively higher than the $8 million.
Well, I think all that we know is how the minimum royalty was calculated, which was you took 80% of the revenue and then you multiplied that by 0.7.
I mean, I'm just, if you're asking us to look at the commercial common sense, then the minimum royalty has to be looked at against the background of what was being paid in 2014. But nobody thought to tell the court that.
I think we know that it was paying something more than the minimum royalty because we know that.
Well, I guess.
No, but we know that from the way the minimum royalty was calculated, because the minimum royalty was 80% of the revenue times 0.7, 0.7 being the then current percentage on the.
And at that time, it was uniquely using the Virgin brand, was it?
Exactly so. Exactly so.
Right.
In which case, given that was only 80% of the revenue, one can.
So it was a little more, or not much more.
It was, well, I suppose it would be 20% more, yes. Something like that.
But even if Virgin America or a purchaser of the company, still Virgin America, rebrands, it would be of vital interest to it that at that point it didn't suddenly find that another airline was using Virgin brand.
Exactly so. And that is, I entirely agree, my lord, and that is a very valuable commercial right that you'd expect to have to pay for. That's exactly
why I drew attention to 3.3.
Exactly so, the exclusivity. My lord, I agree with that. And we submit, none of this is any more commercially unreasonable than a fixed term lease of property. I mean, an IP license is really no different in that regard. If you don't use it, well, that's fine, but you've still got it. You can decide to use it at any time. Nobody else can use it, and you pay for that valuable right. And if we take a quick example of two cafes operating on the same street, one cafe decides that it wants to be the only cafe operating on the street, so buys the other one out, including its property lease, and decides to stop using the acquired property as a cafe at all. In those circumstances, there's nothing uncommercial about the rent continuing to be due and payable, even though the property is no longer being used as a cafe or at all. And I should add that Alaska's suggestion that the judge only took into account Virgin's perspective is demonstrably wrong. He took into account both Virgin and Virgin America's perspective.
It says so.
And he says so in terms, exactly so, my lady. So stepping back, we say that the factual matrix, the commercial considerations all point in the same direction as the words of the contract, and that therefore this court should dismiss ground 1 of the appeal. And I was going to turn to grounds 2 and 3 relatively briefly. Unfortunately, and this is entirely my...
You don't need them, do you, Mr Toledano? If you're right on ground 1, you don't need 2 or 3.
That's definitely true. I don't need them if I'm right about ground 1.
And if he's not, he might.
He might, yes.
Exactly.
If I'm going to explain why Mr Crow is not making this.
I was about to apologise to the courts. It's entirely my fault. We had not done what my learned friend quite rightly did, which was to discuss that beforehand. I don't feel it's fair to...
Well, I absolutely don't think it's fair, but just for future reference, it is good practice now, always, to discuss whether it's possible for the junior, and in this case it would have been preeminently possible, as we've heard from Mr Ho's excellent submissions.
I entirely accept that, and that's why I apologise for not having done that. Certainly we are already very much doing that at trial. Something that we're acutely aware of and we have been doing, but I apologise.
Quite nice to hear, actually, because sometimes judges do have an effect, which is quite nice.
We are doing it. It's obviously a fantastically good idea, and we are doing it. And I apologise for not having done it on this occasion.
No problem at all.
Ground 2, which is the partial year point, it just relates to 2019. If the court is against me on ground 1 and we're minded to allow the appeal on that ground, the question then arises as to what's the correct analysis in relation to 2019, given that Alaska ceased use of the Virgin brand at the end of May 2019, partway through the year. We submit that at the end of the year 2019, the minimum royalty would still be due in accordance with the machinery and the contract, whereas Alaska says only a pro rata amount of the minimum royalty would be due, and there'd be no obligation to pay the minimum royalty from the moment of cessation of all use. And as you know, the judge agreed with Virgin on this ground, on this partial year point. We submit the judge was obviously right. The quarterly payments between January and May 2019 were less than the minimum royalty, and therefore at the year end, clause 8.6 of the contract requires a top up to be paid. Even if Alaska is right about ground 1, in a year where there's been some use of the Virgin brand, there must be a requirement to pay the top up to the level of the minimum royalty, because that simply results from the annual reconciliation process looking back at the
I
entire
thought
year.
Mr Weisberg had accepted this in argument.
Yes, so did I.
Well,
even if one sticker had gone on one seat on one flight, that the minimum royalty be payable.
he does it. He did accept that, but I think what he would say is the minimum royalty is payable, yes, but only up to the moment that all use ceases, and at that moment, even for the balance of the year, there's no minimum royalty due, and that's
What
why
happens if you come back and do some more usage later?
Well, that's why I said one of the problems for his case is that there's no machinery in the contract for apportioning minimum royalties or for stopping and starting and coming back
But there
again.
is a machinery. The machinery is you pay X per year.
Correct. Exactly.
That's what it says.
That's what it says.
That's how
And
it defines it.
and there's no other machinery.
Yeah.
Now,
It completely undermines the concept of a minimum royalty.
Yeah.
it is. And the fact that it's an annual reconciliation and an annual payment and so on. Now, Alaska relies on one point of contractual analysis, which is that there's a reference in the definition of minimum royalty to a pro rata amount in the case of a partial fiscal year. But a partial fiscal year deals with the first and last years of the contract, which didn't begin on the 1st of January, but rather on the date of the IPO, which was the 19th of November. Partial fiscal year is obviously not the same as a year in which activities using the Virgin brand cease partway through the year. But my learned friend seems to try to use those words as if it could be used in a partial use year, which is not what is said at all. So that's ground 2, and very briefly, ground 3, as the court knows, that concerns 3.6, and it might be helpful just to remind ourselves what that says. That's at page 208 of the core bundle. And so what it says is, subject to 3.7, Alaska undertakes that for so long as it provides the license activities, it shall continue to do so using the names and use all reasonable efforts to promote its conduct under the names. Now, we submit it means what it says. People love to say that, but that is our case on 3.6. If Alaska continues to provide the licensed activities, it is required to do so, at least to some extent, using the Virgin names. And we submit that my learned friend's construction renders the first part of 3.6 entirely meaningless. Alaska says, well, there's no obligation to use the names at all. Only an obligation that if, at its sole option, it chooses to use them, then it has a reasonable endeavour's obligation to promote. Now, essentially, Alaska says that it can reach that landing as a result of the fact that 3.6 is subject to 3.7. But we say that's wrong, and we gave 3 reasons in our skeleton as to why that's wrong, as to why the judge was right to say that it was wrong. First of all, the fact that 3.6 is subject to 3.7 doesn't assist Alaska. 3.7 is permissive. It says non-branded activities may be carried out. It doesn't say, 3.7 does not say that all activities may be carried out without any use of the brand. So it doesn't help to say, well, 3.6 is subject to 3.7. The second point is that Alaska's construction gives no meaning to the words in the first part of 3.6. In other words, the words, it shall continue to do so using the names. Now we, as you've seen, rely on authorities that say court should give meaning to each part of a document. Now, this is not one of those cases, as the court will obviously know, there are those cases that say the presumption against surplusage is a very weak one, that never decides cases and so on. But that's where you have those clauses where multiple words are inserted by the draftsman in order to hit the same target. And that's where the presumption against surplusage is weak. Here, you have an operative clause, clause 3.6, that the court's starting point will obviously be to give meaning to. And given the apparent tension between 3.6 and 3.7, the essence of our argument is actually about harmonising the different clauses, and that's why we relied in our skeleton on the judgment of Lord Hope in the Gaze against SocGen case. He referred to the court doing its best to reconcile two provisions that might seem at first blush to be inconsistent with each other. And that same desire to harmonise and reconcile is also evident from this court's decision, the Court of Appeal's decision in the Bindra against Chopra case, where the Court of Appeal upheld the decision of Mr Justice Etherton, who had sought to give meaning to two clauses in a contract rather than rejecting the second of them as repugnant to the first of them. Now, our construction harmonises and reconciles, but that's because we say 3.6 means that Virgin America must use the names at least to some extent, whereas 3.7 means that it's entitled to carry out non-branded activities. Those two can work perfectly well together. By contrast, Alaska's construction doesn't even attempt to reconcile. It simply says there's no content to the wording in 3.6, shall continue to do so using the names. And the final point, I hesitate to make this point because I'm sure the court's going to tell me this is completely irrelevant. I'll make it anyway now that I've given that introduction, which is that the possible tension between the two clauses was known to the parties at the time of conclusion of the 2007 TMLA. It was pointed out during the DOT certification process by Delta Airlines. The relevant extract is in our skeleton at paragraph 57 on page 70 of the bundle. Delta referred in terms to the apparent conflict between the two draft clauses. The parties nonetheless retained both clauses in 2007 and again in 2014. So this cannot be waved away as an error that nobody spotted, and obviously we submit the court should strive to give substantive meaning to both clauses and to reconcile them. So unless I can assist the court, those are my submissions.
No. Thank you very much, Mr Toledano. Mr Weissenberg.
My lords, my lady, I'm going to start with the judge's findings and the absence of the respondent's notice and Virgin's defence of what the judge found. For that, one takes up the judgment.
Is this in your skeleton?
My lord, yes, I mean, we criticise the judge's...
Did you criticise the absence of a respondent notice?
No, I didn't.
But you're not taking that point.
No, I take it as lightly as I made it in...
Jumping on a judicial bandwagon,
no,
sure.
No, my lord, I'm not, because I'm sure if I had made that point hard in my submissions, your lordship would have made the point that your lordship is now making to me. Really, my focus is...
Your focus is on the judge's...
On the judge's findings.
Yeah.
And I'm interested in what the judge has found and why we say that the judge is wrong. And one picks it up at paragraph 150 on page 135 of the hard copy, 138 of the electronic. What the judge does in paragraph 151 is to say that he will approach the matter chronologically. Now, in doing so, he is adopting the approach that both parties urged on him. During the course of the submissions this afternoon, Mr Toledano sought to distance himself from the factual matrix evidence and the background evidence. Now, I wasn't at the case management conference where directions were given.
Very convenient, Mr West.
Absolutely. Mr Mellor then had carriage of the litigation. But what one knows from the particulars of claim is how one got to this position. And if one goes to the particulars of claim, which are in tab 10 of the same bundle, and I'm sorry to jump around, If one starts at page 154, which is 157 of the electronic, one sees background. This is the pleading by Virgin, and extensive background material is then pleaded. One looks, for example, at paragraph 13, where there's reference to the 2005 TMLA.
I thought you were going to say this, yes.
Paragraph 14, the
started.
DOT. Paragraph 20, we see an express reference to the reason why clause 3.7 was included, and it is said that it was to meet the DOT's concerns regarding Virgin America's ability to operate independently of the Virgin brand. That's in relation to the 2007 agreement, but similarly, if one goes on to paragraph 25, one sees against the background set out in paragraphs 12 to 24 above, then there is the terms of the current TMLA being set out. And then one goes to paragraph 27, page 167, paragraph 27 on a true construction of the current TMLA against the background set out in paragraphs 12 to 24 above. So at that stage, Mr. Toledano did think, and Mr. Crowe did think, that the background was relevant, and understandably both Mr. Ho and Mr. Mellor decided to answer that case. At the CMC, in front of His Honour Judge Pelling, there was argument, or there was agreement, I don't know and I can't tell the court, but in any event expert evidence was ordered. But the crucial question is, what did the judge find? And if one goes back then against that background to paragraph 150 or 151, we see the judge starting at 152 with submissions made to the DOT. We see the judge accepting the evidence of Mr. Podboreski and Mr. Lehman, that the question for the DOT was whether Virgin America was a US citizen. I accept that in this regard the corporate and financial arrangements relating to Virgin America were relevant. Accept Alaska's contention that the DOT were concerned in relation to the question of whether Virgin America was obliged to pay royalties to Virgin for earnings made from non-branded activities. This is clear from the correspondence. Then the judge says the question would therefore arise in the context of construing the 2007 TMLA of how to construe clauses 3.6 and 3.7. And what the judge then does, in very summary form, is to reach a number of conclusions. He says...
Including that it's not particularly relevant.
Well, absolutely.
154.
Absolutely, my lady. We would say that was wrong with respect to him. But in any event, that is the analysis that he undertakes in relation to the interrelationship of clauses 3.6 and 3.7. And that is the extent of the detailed analysis that he undertakes in relation to the effect of clause 3.7 on anything in the agreement. What this judgment lacks is the type of analysis that I have undertaken in this court by showing your lordships and your ladyship that the manner in which one has to construe clause 8 by reference to clause 3.7, and how one can take those two clauses together to mean exactly what Virgin contends for. Sorry.
One of the
What
reasons
Virgin
why-
America
one of the
contends
reasons
for, what
why
Alaska contends for.
2007 agreement can't be relevant here is that the key question is the minimum royalty. And there wasn't a minimum royalty in 2007.
I accept that. And what the judge then does is to go on to look at other aspects, and I don't seek to challenge what he says in paragraphs 157 to 160 by way of factual background. But that is factual background. When one comes to the analysis, it's paragraph 161. And where he starts is clause 8. That's paragraph 161.1. And although one is entitled to start as a judge wherever one wants, what one then needs to do is to go back and analyse by reference to clause 3.7, in this case, what is meant by clause 8. And he says,
Or vice versa.
or vice versa. Absolutely, my lady, I accept that, save that clause 3.7 is the overriding clause.
Yes, of course.
What the judge then says is that the minimum royalty is a defined term. I don't disagree with that. It's a set sum payable for every year of the contractual term, subject to clause 3.7. I don't disagree with that. Regardless of the level of usage of the Virgin brand. Again, subject to 3.7. Again, I don't seek to challenge that. That is clear from the definition of the term and from the clause setting out how that sum is to be calculated. Just as that minimum sum falls to be paid if some royalties, not a defined term, are earned in a year but fall short of the minimum royalties, so if no royalties are earned, it remains the case that the minimum sum has to be paid, again, subject to clause 3.7. Then the nub of the judge's findings are contained within paragraph 1612. I do not think that the fact that the minimum sum is expressed as a minimum royalty means that it must be derived from royalties in fact earned. But that's not the correct question we would submit. Alaska itself contended that for Virgin to be correct, the minimum royalty would have to be a flat fee rather than a royalty. Well, that misunderstands, we submit, the submission that we made, because what we were saying was that clause 8 and clause 3.7 read together demonstrate that the minimum royalty is a royalty. If that's right, then clause 3.7 has the effect of making no royalty, including no minimum royalty, payable in the event that there's no use. The judge then goes on to say, in my judgment, that's exactly what the minimum royalty is. It's a flat fee payable for the right to use the Virgin brand, whether or not that right is taken up. But again, that is subject to clause 3.7. Because as I've shown the court, and as with respect to Mr Toledano, Virgin hasn't, in my submission, sufficiently answered, is how one construes clause 8, the A, B, C of revenue-based royalty, and the minimum royalty provided for in that clause, in the context of saying, in the absence of use of the brand, clause 3.7 then has an effect. And we say, in 1612, the judge simply doesn't grapple with that conclusion. Virgin, we submit, hasn't grappled with that conclusion. And the answer is, we submit, clear. Because if one takes 3.7, 8.1 and 8.6 together, one sees that royalties are to be treated for 3.7 purposes as part of 8.1 and 8.7, 8.6.
But isn't that exactly what the judge is finding against you in 1612?
Well, yes. Unexplained, no clear ratio as to...
He hasn't spelt it out in words of one syllable, but what he's essentially saying is you knock out the non-Virgin activity from A, B and C and calculate that in clause 8.1.
Well, my lady, what he's saying is effectively that a minimum royalty, capital M, capital R, isn't a royalty for the purposes of clause 8.1.
Yeah.
Or 3.7. That's how I read it.
Or
Or 3.7, crucially for 3.7, absolutely.
Yes.
Except he never mentions 3.7 in this context.
And we say that's a
To tell us
fundamental
what
error.
it meant in 2007, which is not relevant because the minimum royalties weren't in place. I mean, this all helps you in a sense, but sort of doesn't help you if he was right for the wrong reasons.
I accept that, and that's why I've been realistic
Yes.
in seeking to address the arguments that were put by Virgin.
Yes, indeed, and you've very sensibly addressed the interpretation points that Mr. Toledano has made in your skeleton. Now, he hasn't. I mean, I'm not trying to stop you, but he hasn't actually gone very much further in his oral submissions than he did in his skeleton.
I would accept that, and other than in relation to scenarios, I think I can hopefully be relatively brief.
Yeah.
But just while we're still on what the judge finds,
Yes.
we say that the distinction that the judge draws in that paragraph between the right to use and actual use is illusory. It's illusory in the context of this particular agreement, because this particular agreement allows for money to be paid by the licensee to the licensor, irrespective of of the amount of use that in fact occurs. Because the minimum royalty has the effect of meaning even a de minimis use generating a limited amount of revenue produces a payment. And we say that demonstrates that this is not an agreement that is just looking at royalties about use. It is an agreement about royalties of the right to use. That distinction does not mean that Virgin is right. What one says is, this is an agreement where there is a mass of different rights. There is also payment in respect of those rights.
You say there's no distinction between the two different types of payment, and the fact that they've been labelled royalty and minimum royalty doesn't matter, because 3.7, the whole thrust of 3.7 is you don't pay anything.
Absolutely.
That's really the number.
That's the number.
And you say, well, if we're getting something for nothing, well, that was the bargain that they struck, and that's just hard luck. And in any event, they're not getting something for nothing because they've got the right of termination.
Your Ladyship has summarised what I was about to say more elegantly than I am. Certainly more succinctly.
But that's effectively where we are.
Absolutely, my lady. And so when one then begins to get into elements of commerciality, the likelihood of a debrand can inevitably cut both ways. Similarly, the difficulties of relicensing, those again cut both ways. It's difficult for Alaska to rebrand and organise its fleet. It is difficult for Virgin, or it may be difficult for Virgin, in fact, to relicense the brand. But those commercial aspects shouldn't, we submit, mean that the clear wording of clause 8.1, 8.6 and 3.7 should be interpreted in a different manner. So, both for debranding and relicensing, neither of those arguments, dealt with in part by the judge, at least in relation to debranding, that's dealt with expressly, where the judge accepts that, and that's 1582, that by virtue of the changes in the control structure, the risk of a debrand was increased. He recognises that again in paragraph 1613, where he says there's an enhanced risk of a debrand. But in those circumstances, we say the debrand does not mean that the wording that we contend for needs to be interpreted in a particular way, because the judge has only looked at it in that context from the perspective of Virgin. It has not sought to say that the risk of a debrand is as likely to mean that our interpretation of clause 3.7 is correct. Why? Because if there is a debrand, and if the decision is taken that the brand is no longer important to the airline, why shouldn't they be able to step away from the agreement in terms of continuing payment, particularly in circumstances where the DOT has said it's important that the airline keeps its independence?
Makes you wonder why they're actually continuing with the agreement at all, if you're right. In those circumstances, they decide they're not going to use it. They decide they're not going to pay. Well, what use does the agreement have from your client's perspective?
But the agreement has no use from my client's perspective. And if Virgin want to take back their brands, they can. They're entitled to do so.
But you can't walk away from it. So you're actually lumbered with an agreement that on your analysis is of no commercial use to you whatsoever.
Absolutely. And that is precisely the type of problem that Virgin America is being forced to confront, or Alaska now being forced to confront.
Except, there's my Lord's point, which is that you can still stop somebody else using the brand in competition.
Well, if Virgin decided to take the decision of giving someone else, or wanting to give the brand to someone else, they could. So we could not stop Virgin from doing it. Indeed, if there was not material use during the course of the license agreement...
Well, they'd have to terminate, wouldn't they?
Absolutely.
Isn't it pertinent that in the circumstance where you completely reback brand and stop using the Virgin brand, a right to terminate is given to Virgin, but you are not given a right to terminate? And why would that be? To preserve your ongoing obligations So what are your obligations?
You said there
The
aren't
only
any.
one is paying a minimum royalty.
Subject to non-use of the brand.
Well,
If there's non-use of
that's
the
the
brand,
point I'm making. You don't have the right to terminate. And why would that be?
because the agreement itself anticipates that at some point Virgin America might decide to go back to continue to use the brand if it should want to do so, subject to Virgin not deciding to have terminated.
Why don't you have the right to terminate?
Because
What is the obligation which the contract provides should continue on your part, which you do not have the right to terminate?
we are still subject to the obligation, for example, to report gross revenues. We're still under an obligation to compare what is being.
But that's all a complete nonsense on your analysis.
Makes no sense at all.
In fact, it would be absurd if you've rebranded. You're not obliged to pay any royalty at all, any sums at all, but you've got to carry on reporting.
And the reality is, in circumstances where there is no use, one still says, what does clause 3.7 and 8.1
Well, the
and
reality
8.6
is
mean?
that you continue to be obliged to pay a minimum royalty.
My lord, we say not.
Yes.
Because we say not.
But I'm putting to you that the fact that you don't have a right to terminate, I'm just looking for your answer. It's hard to see any content in the continuing agreement, sensible content, if you are not obliged to pay the royalty, the minimum royalty. Sorry.
I think the answer has to be that Virgin in those circumstances has the right to terminate. The fact that the parties haven't included an additional right on Alaska to bring the contract to an end when it decides not to use the brand is neither here nor there when one comes to construe clause 3.7, 8.1 and 8.6.
Then you'd expect them to have an obligation to terminate, because if it's a right, it's basically an option. They can choose to terminate or not, as the case may be. And on your analysis, you've got no further obligations other than potentially to tell them about your gross revenues, which have no meaning because you don't have to account for any money from those gross revenues. You don't have to pay them a penny or a dollar as a result of all of this. They've got an option to keep the contract alive, but you've got no obligations under this contract. I think my lord's making a fair point that commercially there's absolutely nothing in it for Virgin to keep this alive, and yet they've got an option to terminate, not an obligation to terminate. And you, on the other hand, are stuck with this contract like a millstone round your neck, which you say gives you no rights and no obligations.
The position for Virgin is whether they want to allow the agreement to terminate so that they can relicense. The position for Alaska is that there is no express right to bring the agreement to an end. Absolutely, I accept that. But does that mean that my construction of the relevant clauses is wrong? My lord nods. I would respectfully disagree. And I would disagree because in many circumstances, the court will say the absence of a particular thing means that something has to be wrong or something has to be right. Here, what the parties have done is direct their minds in the context of the regulatory environment, in the context of the previous agreements that have been reached. They have reached a position where they make amendments to an existing agreement which provides that no royalties shall be payable in the event of non-use. Does that mean by failing at that moment to include a provision allowing for termination in the event of non-use, to suggest that that means that our construction is wrong, my submission isn't right?
Well, you're postulating a scenario where a contract continues under which neither party has any sensible rights or obligations. It's become a complete empty vessel, hasn't it?
Yes, but that doesn't mean that
Well,
my
it's
construction
not-
is uncommercial.
Well, I think it rather does mean it's uncommercial, because we don't normally assume that commercial parties have entered contracts which sit there as empty vessels.
Well, it is the position that the parties reach as a result of the regulatory involvement. It is the position that the parties then have because of commercial choices that they have made subsequent to the entry into the agreement. The question then is, what is the impact of those commercial decisions, and what is the contractual framework that governs, in those circumstances, the particular ongoing obligations?
Well, you say, whilst it might be, it might be what's happened in real life. When the contract was entered into, this was but one of many possibilities, and not by any means the most likely, just a possibility. And it turns out that it is left as a rather empty vessel, but that's the way it is on the proper construction of the term.
Yes, and that certainly doesn't mean that the construction, as at 2014, is commercially unrealistic.
Yeah, yeah, I see that.
Then I'd like to turn to Virgin scenarios. And Virgin scenarios could play a role in the language of the clauses, or could play a role in the commerciality of the clauses. And I'm not entirely clear what they do, but I'm going to address both possibilities. The three scenarios that seem most to be in play are scenario 3, which is no commercial activity, scenario 4, no activities in relation to Virgin brand at all, and scenario 2, which is the mixed type of activities. Now, from a language perspective, and I'm going to look at scenario 3 and scenario 4 first, and then I'm going to look at scenario 2. From the perspective of scenario 3 and scenario 4, from a language perspective, clause 3.7, we say, anticipates that Alaska may cease to use the names and marks in a material manner. And I've already made submissions as to what materiality might mean. And similarly, I've already made submissions as to the second half of clause 3.7, which it provides the remedy. Now, in both scenarios, scenario 4 and scenario 3, there is an absence of use. And we say, in those circumstances, the effect of clause 3.7, 8.1 and 8.6 is no use, no pay. And we say it is not necessary for clause 3.7 to have express words that say, if you don't use the brand, no royalties are payable. That, we say, is the inevitable construction, interpretation of the agreement when one looks at 8.1, 8.6 and 3.7 together. Now, in this context, Virgin says that the words or any other activities have particular import. And they say that those words would not include a complete cessation of activities. We say, as a matter of language, there is no reason why an absence of commercial activity, that being the particular focus of Virgin's arguments, should not also be included within the words or any such activities. As a matter of construction, interpretation, if the licensee is doing nothing at all commercially, why should royalties be payable if there's no use of the brand or marks and Virgin decides to allow the agreement to remain in force? So that's from a language or a linguistic perspective. From a commercial perspective, one can test it this way, because one can say, well, the absence of any activities at all suggests bankruptcy, or one of the possibilities may be that there's bankruptcy. In those circumstances, why, if there's no activity at all, should the insolvent company have to pay a minimum royalty? Why is that a protection for Virgin against what it says is a risk that it wants protection from? As I've said, we know, because the judge has found, that there was an anticipated debranding as at 2014, or the risk of debranding had increased. In those circumstances, one can say, well, why would the parties, and particularly in this context, Virgin America, agree to pay royalties where there is no activity in circumstances where it could, on another construction of the clause, say, well, we're going to go into the catering business, to adopt my friend's cafe analysis. If Virgin America went into the catering business and abandoned the aircraft business altogether, it would be undertaking activities, we say, in those circumstances, scenario 3 and scenario 4 don't reveal any real or material problem for the purposes of Alaska's argument. So that's what I want to say in relation to scenario 3 and scenario 4. As to scenario 2, and scenario 2 is the mixed use scenario, we say that there's nothing anomalous about it when compared with scenario 4. Why? Because 3.7 gives Virgin America the right of election. If it decides to use the name or marks, then the minimum royalty kicks in. If it does not, then there is no minimum royalty. That is not, we say, unattractive or anomalous. That's what the language of the clause entails. It is also, we say, consistent with the requirements of the DOT for independence. And my friend, during the course of his submissions this afternoon, showed the court extracts from the various DOT orders which emphasise the importance of independence. What the clause, we say, is not about, it is not simply about non-branded commercial activity. That's effectively Virgin's argument, but that's not what the clause says. The clause looks at royalties in the absence of use of the name or marks. That's why we say scenario 2 doesn't assist in coming to a conclusion adverse to Alaska.
I just want to make sure I understand your point on scenario 3. Are you saying clause 3.7 applies whether there are no revenues at all?
Clause 3.7?
Yes.
If there is...
applies in a scenario where your clients are not having any revenues at all from anything. In other words, they've merged with another airline or something of that nature.
Depends whether this entity still exists. But assuming that the entity still exists, it is involved in some shape or form in existing. It is involved then in some form of activity. Mm-hmm. So directors will be meeting, or directors will not be meeting as regularly as they might otherwise have met, but nonetheless there is still some living entity. Those activities are sufficient to fall within the terms of clause 3.7. In those circumstances, those activities...
even though they wouldn't be generating royalties of any kind?
Yes, my lady. As long as there's no use of the names or marks. If there's use of the names or marks without generating revenue, then clause 3.7 does not bite and the minimum royalty would apply. So the example would be, suppose the entity, the licensee, had a website which continued to display the Virgin marks, not earning any revenue from that website at all. It would not be able to say that it was not earning any, it was not using the names or marks. As a result, you're then into clause 8.1. In relation to clause 8.1, there is no revenue connected to that display of the names and marks on a website. As a result, you're then driven to the rider in clause 8.1, and then the minimum royalty would apply. And that is the impact of including the minimum royalty and the revenue-based royalties within the same clause. Then, very briefly in relation to factual matrix and commercial purpose, I've made the point already that it was, at least initially at the instance of Virgin, that the factual matrix should be explored. The points that I would emphasise in relation to commercial purpose are these: that the D brand was more likely, and I've made that point already. The situation in this case is that what one saw was an IPO being undertaken, and in those circumstances one can infer that the person selling the shares, i.e. the Virgin entities, was pleased with the result and wanted to obtain value from the investment that they'd made. What we say is, in this case, as to purpose, those matters are matters that cut both ways. They do not provide an answer as to why our construction of 3.7 is wrong. If anything, they support our construction, but on any view, we would say, ultimately those are neutral, and the court should simply look at the words of 3.7 and 8.1, 8.6 and 3.6, which I'll come to in a moment, to reach a conclusion. What one needs to bear in mind in this case is Alaska is not excluding, in practical terms, others from being able to have access to the Virgin brands and marks. Why? Because Virgin can take those rights away at any moment in time. And what the court heard below was the attempts that Virgin made and the discussions and negotiations Virgin had consequent on Alaska's announcement that it intended to debrand. And when one looks...
We don't talk in those terms. It's not Alaska isn't doing anything. It's the contract that does that.
That's right, but as with many things, it takes two to tango. And in circumstances where there is a contract that exists, there are rights and obligations under the contract, where one party has decided to do one thing under the contract, in this case, not use the brands or marks, the other party is given various other rights. Now, what was being put to me this morning and what Mr Toledano sought to submit to the court this afternoon was that it was important to perceive this contract as excluding others from the market at the instigation, in effect, of Alaska. That is not Alaska's position. Alaska's position is that Clause 3.7 properly balances those two requirements. The requirement to pay royalties in certain circumstances and the ability on Virgin, should it wish to do so, to take back those rights. Finally, in relation to Clause 3.6, as I noted this morning, Clause 3.6 expressly states that it is subject to Clause 3.7. So the draft person has decided to make it clear that whatever 3.7 might do, Clause 3.6 will effectively have to like it or lump it. And that ultimately, we say, is the answer to the questions posed by Virgin as to surplusage, because surplusage normally only comes into play in circumstances where it is difficult to know why one clause exists and another clause also exists, and where the balance falls between those two clauses.
Do you say that 3.6, when read with 3.7, means that if your clients are going to carry out mixed use, so during the period of debranding, for example, whilst they are carrying on activities that are licensed activities, 3.6 conditions that, so you're obliged to do all the various things that you're supposed to do under 3.6 in relation to that, and it doesn't have any bearing on the non-licensed activities, which are the others.
Correct.
And then when you cease to do any regulated activities at all, which you say 3.7 allows you to do, then 3.6 has no meaning.
Yeah, absolutely.
Is that really the thrust?
That's the thrust of it.
Yeah.
That's the answer, and that's why the analysis of 3.6 doesn't assist ultimately in the question of contractual construction that the court has to undertake.
Yeah.
Forgive me, I do have a difficulty with the way you expressed it, because contractual interpretation is the matter of looking at a battle of clauses, where you say clause 3.6 has surrendered ab initio because it said subject to clause 3.7. So therefore, if we can see any tension between the two, we just disregard 3.6. The process of interpretation we use is we say, well, clause 3.6 is expressly referenced 3.7. So they're intended to be read together, but the the parties have agreed that the obligation in 3.6 has to be understood as being subject to 3.7, but that doesn't mean you ignore 3.6 or in some ways just gets thrown out. You have to look at them and try and make sense of them and all other clauses together.
That I absolutely accept, and I didn't understand my lady's point to be that one throws out clause 3.6 entirely. It's not a question of surrender.
I came back to what you had said.
What I submit is that 3.6 is subordinate to 3.7 when it matters. And when it matters is in precisely the circumstances where there is no use of the brand or marks. That's the first sentence of 3.7. And in those circumstances, one cannot complain under 3.6 of an absence of reasonable efforts to promote the names and use the names because a decision has been taken to elect to perform the licence activities without the payment of royalties.
If 3.7 means what you say it does and enables you to elect to decide never to use the brand ever again, then 3.6 can't be read consistently with that, you say, so as to impose an obligation on you to use the brand again.
Correct. It doesn't have a positive obligation on Alaska to use the brand. What it provides for is that while it is providing the licence activities, it will use the names and all reasonable efforts to promote its conduct of the licence activities, save where it is elected not to perform the licence activities without the use of the names or marks. And that's how the two clauses can be read together. Those are my submissions, unless the court has any further questions.
Mr. Ho doesn't want to respond.
I do not, my lord, unless it's something I can assist the court with.
No, thank you, Mr. Ho. Good. Well, thank you all very much. That's very good timing. We will take time to consider our judgments. We're not intending to deliver extempore ones now. We'll be relieved to hear. We will hand them down in the usual way. When we do, they are, particularly in this case, which may be commercially sensitive, they should not be used for any other purpose apart from the agreement of an order and costs. Please, the embargo is very important. And then agree those matters, and if you can't agree them, we'll deal with them in writing. And if you can't agree a timetable for submissions, we'll tell you what that timetable should be, but I would have expected that you will be able to. So thank you very much, all of you, including the juniors and solicitors. A very well prepared case, even if it went a bit long below.
Court rise.